Good morning. I'm Michael Wild, and this is your estate planning minute. So today I want to talk about beneficiary designation forms. In the last week, I've had a number of clients call up with issues because their minor children were named as beneficiaries of life insurance policies, of bank accounts, brokerage accounts, whatever it may be. And that's an issue that many of us face with children. Is we want to make sure that our children are named as our primary or contingent beneficiaries to make sure that they get our assets. At the same time, we fill out one of these beneficiary designation forms and we list a minor child who is also a minor at the time that we die. They can't inherit. The insurance company, the brokerage company, they can't give a check to a minor child. So what do they have to do? They have to give it to a guardian. Now, it's not guardian like you and I are thinking about, where you would say, okay, well, I die, my wife is still alive, she's the mother of my children, they get the money, she will manage it for them. Or I named a guardian in my will, they're raising my children, my mother is the guardian of my children, so therefore she'll manage the money for them. It doesn't work that way. When it comes to distributing money from a life insurance company, a brokerage account, or whatever it may be, what has to happen is a legal guardianship has to be set up through the courts. This is a long process. It is an expensive process. It is one that can be avoided. How do we avoid it? Living trust. We set up a trust while we're alive that can act as a safe or a bucket where all these assets can pour into. So now what we have is we have this destination, this trust that we set up while we're alive. It still exists after we die, although it will get its own tax ID number. And then when that bank or insurance company or brokerage house says, we have a check to issue to the beneficiary, who is the beneficiary? It is the trust. They issue the check to the name of the trust. The trust already has an account. The trust already has a successor trustee named, and then we can avoid that lengthy, expensive guardianship. So, lesson for this morning is make sure if your desire is to name a minor child as either a primary or a contingent beneficiary, do not do so. Instead, have a trust formed. It is not expensive. It will act as the beneficiary in place of the children. You can name the children as beneficiary in the trust, but on the beneficiary designation forms, you can only list a spouse or a trust. Everyone else should be in the actual estate planning documents. So that's your estate planning tip of the day. I'm Michael Wild, and please tune in for more.